All right, let's move on to a topic of much less interest. I want to talk about a case that arose out of Texas, and for that I'm going to turn to Steve. You know something about the ASARCO case?
I've heard a thing or two about it, and I think that is probably why people came to the breakfast this morning to find out how we are going to deal with the ASARCO decision. And I think, as everyone knows, it is, as an estate professional, you have to file an application to have your fees approved before the debtor's estate can pay them. So if you file your fee application and someone opposes it and you spend time and resources to defend that fee application, who should pay for that? Should it be the debtor's estate, as Baker Botts and their co-counsel were arguing, or should that be something the professional should bear on its own? The Supreme Court has now pronounced that, based on the plain wording of the statute, that the estate should not be responsible for an estate professional defending the fees for which it is seeking. I think the bigger story on that, the Supreme Court, at some point I don't think we're going to change a bankruptcy judge's mind that the Supreme Court was wrong, so we have to deal within those parameters. So I think the bigger question is, how are we going to deal with that decision on a go-forward basis?
How are you going to deal with it? You do a lot of debtor work?
I can tell you what other people are doing, then I'll tell you what Weil is doing in the meantime. But we've seen several of the cases in Delaware where the professionals are modifying their engagement letters to provide variations of the debtor agrees, or in a couple of cases the statutory committee agrees to indemnify the professional in respect of any expenses or fees it may incur in defending against a fee application. The idea being that the Supreme Court left open in ASARCO the idea that the American rule, which says that each side pays its own fees, can be altered either by statute, which they already disposed of, or by contract. And various professionals are asking the court to approve modifications in their fee engagements or their contracts that provides for payment of fees for defense of fee applications.
And the U.S. trustee is opposing that, right?
In every case, the U.S. trustee has opposed.
Now, there was an application like that pending before Judge Walrath. I hadn't heard that she had ruled on that.
I haven't either.
I
tried to look it up and I couldn't.
I checked on that yesterday with my Delaware friends, and they said we are all waiting.
Yeah, I haven't.
Have you seen any other rulings on it?
We have not. And in the other cases, the orders that are being entered now are that the professional has asked for this, the retention is approved, subject to when a decision should come down in either Judge Walrath's case or the other case, then people can go back to court and get a further approval or not of their engagement letter that would provide for this provision for payment of fees for defensive fees.
So what is Weil doing?
We have drafted a modification to our engagement letter. We have not used it yet. We filed a Chapter 11 case in the Southern District a few weeks ago. We did not ask for this kind of arrangement there. We are waiting to see what the Delaware courts do with respect to the modification to our engagement letter.
Professor, you've done a lot of work on attorney's fees. What do you want to say about this?
Well, what the U.S. trustee is trying to do is it seems to me, is to take the broadest possible reading of the Supreme Court's decision, which does have some broad language in it, and push it even a little bit further, right? Because the Supreme Court's decision is...
You want to talk, when you said the U.S. trustee, you want to talk about what the U.S. trustee published on this issue?
Yeah, so they have a series of questions and answers, which basically says, if I do this, will you object or not? And the answer is almost always yes, it seems like.
Is that true for everything?
Yeah. Yeah, if I do this, will you? Yes, we will object. So, I think part of the trick here is right, the U.S. Supreme Court, and this goes back to some of the comments we made about in consumer bankruptcy, I think it applies here as well. The Supreme Court's decision is almost wholly focused on Section 330. It doesn't engage with Section 328 at all. So you really don't know what to make of this. I mean, they do say that you could change the rule by contract, and they didn't talk about Section 328 at all, which seems to allow you to do things by contract. The court, and you and I have talked about this privately before, about how the court, and courts often don't do this, don't engage with the broader system in the code of how professionals are retained, 327, 330, 328, and didn't try to put them all together. It just focuses on 330 and says, hey, this doesn't expressly override the American rule, so too bad for you, you lose. It seems to me, on the other hand, right, to take the U.S. trustee's position, some of the engagements, especially one in particular in Delaware, seem to be a little bit broader than I would be totally comfortable with. They may allow the professionals to be indemnified even in instances when they wouldn't have been indemnified pre-Baker Botts. So maybe we don't want to go there either.
It was common practice, wasn't it, for investment bankers when they got retained to have a provision in their engagement letters that said their attorney's fees would be covered.
Right. So one of these cases in particular seems to be going to the full investment banker model, whereas as I understand it, the case law prior to Baker Botts was more of the court had discretion to give you fees for fees in certain cases where they thought it was warranted. This would be you get it in basically every case, right? You get fees for fees, which is a little bit more than the prior case law allowed. I would be more comfortable going back with the, in special cases like the Baker Botts case, which involves really sort of terrible facts where you've got it sort of,
Really?
You're pushing the envelope on a Rule 11 violation, it seems to me, but not quite there, right? And in those situations, the bankruptcy court should have discretion to award fees for fees, it seems to me.
Even the investment banker model had been being cut back a little bit. If you have an investment banker and he's being deposed in connection with the case and he wants his own attorney to represent him in the deposition, I think that is a very good example of why the estate should pay the fees of that professional. But U.S. trustees were coming back saying, look, we're not going to pay the investment banker's attorney to prepare his fee statements, which I took it the U.S. trustee would still object to an investment banker's fees being paid for prosecuting a fee application.
So Baker Botts' mistake in this case was instead of asking for the $5 million bonus, they should have asked for a $10 million bonus and not the fees, and they would have come out ahead?
Well, I've wondered about that, how a judge will rule after Baker Botts if you just don't ask for fees and ask for a bigger bonus.
I have to tell you, what you said preliminarily on talking about this case is really the bankruptcy judge's dilemma on this. There are times I'm sure that I know I sign off on something, you did a great job, I'm giving you every single thing that you asked for. And now we look at what the Supreme Court has said, and the Supreme Court ties my hands. You have to follow the court. So it's a difficult dilemma.
This does seem to be one of those cases in which the way the issue is framed is really important to how the court decides it, right? I mean, I think everyone basically agrees with the principle that lawyers who represent bankruptcy estates, professionals in bankruptcy, should not be better off than lawyers who represent clients outside of bankruptcy with respect to their ability to be paid, but nor should they be worse off. They should be similarly situated. And this is a case that you can view from one or another perspective, right? One way of thinking about this case is, I'm a lawyer representing the client. The client calls me up and says, your bill is too high, and we end up having a dispute about my bill. Outside of bankruptcy, the lawyer who's fighting with his client about the bill doesn't get to charge the client for the cost of that fight. And I think that's how the Supreme Court looked at it and reached the decision it did. There's another way.
In this case, it was actually the client who was objecting. It wasn't a third-party creditor.
Right, but exactly. And I think that perspective on the case played a role in the decision. But of course, the decision itself applies to all sorts of different cases. The more paradigmatic case, right, is one in which the debtor is saying, my lawyer did a good job. We have some holdout creditor who for terrorist value is objecting to the fees.
Or a fee committee or the U.S. Trustee's office.
And the cost of defending your fees is itself part of the work of representing a debtor in bankruptcy. It's part of the work you have to do in order for the system to operate. And when viewed from that perspective, I think it would support the other result, that this is just part of the bankruptcy case, it's part of representing my client. The bankruptcy system itself sets up this process, and the lawyer for the debtor or the committee has to go through it. And I don't think the court was thinking about this case as involving the paradigm situation. It was really driven by the unusual facts in which this case arose.
But unlike the other 3 cases that we've already talked about, this one had a vigorous dissent that made exactly that point, right?
Yes, it did.
So why do you think that didn't sell?
For the same reason that I persuaded no one in Harris versus Vigeland. Sometimes,
Well, I think, this is probably the shorthand. The answer is the vast bulk of the Supreme Court doesn't understand bankruptcy.
Right,
Hard to imagine,
that
isn't it?
plus the unattractive facts of this case.
Right. I mean, the court really just didn't appreciate how many more people can object to fees in a bankruptcy case as opposed to a normal attorney-client relationship.
But even in this case, you say the ugly facts of this case. It strikes me that the ugly facts of this case are the shareholder, the restored shareholder, who got billions of dollars of value out of this, objecting because it had been the defendant in this process. So I would have thought if there was a bad flavor here, the Supreme Court would have smacked them down rather than Baker Botts.
That's right. Look, this is an unusual. It's not only in bankruptcy, right, that you have a giant bet the company litigation over enormous sums, and that litigation is essentially settled by the defendant buying the plaintiff. That's essentially what happened. And outside of bankruptcy, if you're representing the defendant, you've got to figure out a way to get paid before the sale closes, because or else you've got a problem. And essentially, in bankruptcy, there's no way to do that, and that's the unusual circumstance of this case.
What I've been thinking about is, what are we going to do if the Delaware courts come down and say this contract idea doesn't work? Or even if they do say the contract idea doesn't work, how are we as lawyers going to torture that into something else? For example, in the Delaware cases, the debtor is having its contract with its client, the estate, but then there are others representing unsecured creditors committee that are doing a contract between themselves and the committee, but then binding the debtor for payment of those fees. So how is this all going to work out through the process?
Now, the Supreme Court said that there'll be a regulator on the process because the fee objector will have to pay its own fees. What do you think about that, Steve?
I think, in going to the point of Baker Botts may have been bad facts, that objector was a bit of sour grapes. I don't think it cared
Exactly.
what fees it was paying. And in many cases, if it's creditors committee that's objecting to debtors counsel's fees, or the United States trustee, their clients aren't paying the fees, so that's not really
The irony here would be the debtor paying the committee's fees to object to the debtor's counsel's fees.
Right. And the estate is just a source of funding for everyone to fight. And one thing I can see attorneys doing, as they tend to do, is these contracts really are only going one way right now. That if I have to defend my fees, you will pay them. Many of these contracts where a prevailing party wins, it goes both ways. The party that prevails gets to recover fees. And I'm just waiting for someone to say, if you want a contract that says you get your fees if you win, well, then the objector gets its fees if you lose.
So do we have any advice for the audience here on how to protect themselves when they're doing debtor work for this issue?
You mean prior to the Delaware court's ruling?
Yes.
What about involuntaries? Is there any implication in an involuntary proceeding in getting compensation for defense fees?
Well, we have a. I don't want to call it a circuit split. I think that gives it too much credence. But you want to talk about the 2 cases from the 11th Circuit and the 9th Circuit on fees on an involuntary?
Well, we have one in the 9th Circuit. The court dismissed the involuntary petition and determined in one case that the claims were subject to a bona fide dispute and in another case on motion by creditors. And so after the dismissal, the two companies filed for cost, and fees were awarded. And then the Fifth Circuit affirmed the award of fees to an attorneys, and then the 11th Circuit didn't. So
This is for the, for the fight over the fees. So the Ninth Circuit allows it, and the 11th Circuit doesn't. You think Baker Botts is going to cause the reversal of the Ninth Circuit's position on that?
and that's in defense of an involuntary case.
Yeah.
I mean, I guess
Greg,
those are,
you should have an opinion.
Yeah.
I think those are different statutory provisions.
They clearly
And
are.
that Baker Botts, the rationale of Baker Botts really was about the language of 330. And I think this is a fair question on which there are reasoned arguments on both sides. I
But
don't
it's
think.
the fee shifting. They used, what happened was the Ninth Circuit used the fee shifting provision, and so did the 11th Circuit. So, and didn't Baker Botts use the fee shifting also?
Well, to the extent one says, look, the American rule applies and everyone bears their own fees in the absence of a clear provision to the contrary, then Baker Botts, I guess, would be informative here. On the other hand, the real basis, I think, for awarding fees to an unsuccessful involuntary is sort of a form of sanction. And I don't think anything in Baker Botts limits the court's authority to impose that type of sanction for the improper use of the bankruptcy system.
Well, it does give someone a statute to argue if they're in front of a judge in that
Certainly.
matter.
Wasn't that a more clear fee shifting statute for fees for an unsuccessful
303,
involuntary?
yes.
That's a distinction that I saw and thought that that was the main distinction with the Baker Botts decision.
Yes.
I was going to say, I mean, despite all the sort of unkind things we've said about Congress, this is one area where it might even be possible to get Congress to act, especially if there were an explosion of sort of tactical fee objections, so that the firm said, we're able to go to Congress and say, look, we're basically having to raise our rates to all of our clients to insure against this action.
But the U.S. trustee in the FAQ already says, we're not going to permit
Exactly.
rate raising to cover this.
Well, you can't raise rates just for your bankruptcy clients. So if you raise them across the board, then you can go to Congress and say,
Listen.
hey, look, this is hurting people even outside of the bankruptcy
I can
system.
tell you right now,
Yeah.
I think anybody that takes anything to Congress right now may be careful what you ask for. You may get so much more.
And as interesting as that is from the legal profession perspective, there are some market forces that might affect one's ability just
Right,
to impose
right.
across the board.
Right, but if you could make that argument in good faith, that is something that Congress might actually listen to, is that, hey, this is having an unintended effect outside of the bankruptcy system, and then Congress might actually.
Okay, I can tell you something interesting. I don't know if any of y'all were called on the GAO study on fees, and I was called on the GAO study on fees. And one of the things they really wanted to argue to me or ask me about, and I felt I was almost arguing, was how is it that let's just use GM for an example. If you've got GM as a client, you will give them a discount over years because they're your good client. You'll write off some things, you'll do that. But when they're in bankruptcy, quote, you don't write it off. And so to explain to non-bankruptcy people how intense and how you have to, and I used Weil as an example. I said, GM's a perfect example. I happen to know lawyers at Weil who were not in the insolvency group that when GM was getting ready to file, hands on deck, every lawyer was working on that case to the detriment of everything else. I said, that's why you have to pay in bankruptcy cases. To get these intelligent, sophisticated people to understand that was pretty difficult. So try to go convince Congress that your $500 an hour is not enough and that you need to raise fees or whatever. I think there's a tone deafness about bankruptcy right now that I don't know that you could change.
Well,
I had a platform, I used it.
I know fees is of great interest, and I know that all of you have been so anxious to discuss these things, and I think the subliminal message here is that you really don't want to talk about wellness, and you don't want to turn to that, but I'm going to force you to do it anyway.